We are meeting again. Now we are dealing with chapter 35, and the title of the chapter is Previous Inconsistent Statements. So today we are going to explore, okay, I'm sure you guys have been hearing about previous inconsistent statement, previous inconsistent statement. It's just that previous inconsistent statement touch a number of areas within the law of evidence. There's previous consistent statement of sexual cases, the previous consistent statement, just normal previous consistent statements. So, but then today this is a very practical area because it's almost at every trial. Witnesses sometimes say things that don't match with what they said early. I think that's why previous inconsistent statement keep coming up over and over again because likely chances are witnesses don't stick to the same story or don't stick to the story that they wrote in their statement. So our task is to understand how the law deals with these contradictions and what procedures must be followed and what impact has it have on credibility. So what are previous consistent statements? Previous consistent statement is when a witness gives evidence in court that does not line up with the statement they made earlier. You are already aware of this definition. It's been said over and over again. For an example, suppose a witness told the police a written statement that they saw the accused at the crime scene, but when they testify in court, they say, actually, I did not see the accused at all. That is a previous inconsistent statement. It is consistent because it is inconsistent with what you wrote earlier. So what are legal frameworks that actually cover or rather govern this part of the law? So the legal framework is Section 4 of the English Criminal Law Procedure Act of 1865. This section provides that the procedure of handling previous inconsistent statement but basically just gives us a procedure on how to handle these kind of statements. The law then requires fairness. So you cannot just spring to prior statements on the witness without warning. This section provides the procedure of handling previous inconsistent statement. The law requires fairness, and I'm saying this again so it sticks into your head, so that you cannot just spring into prior statements of the witness without warning. So these are the steps to follow. Ask the witness if they've made a previous statement. Example, did you tell the police on a sworn statement that you saw the accused with a gun? And if the witness admits, then you must give an opportunity to explain the inconsistency. Example, if the witness says, I was under pressure when I made the statement, or I was mistaken at the time. If the witness denies, you can then prove that the statement through other means, for an example, by producing the affidavit or calling the police officer who recorded it. So now we're going to be dealing with witnesses' privilege against self-incrimination. Against self-incrimination. So, okay. So remember, a witness cannot be forced to admit something that would incriminate them. For an example, if admitting to the prior statement will expose the witnesses to perjury charge, they may claim privilege. I hope that stacks in. All right, so what are the evidentiary consequences? So what happens if the previous inconsistent statement is proved? It does not automatically prove the opposite statement is true. Instead, it undermines the witness's credibility. And so the court may say this witness is unreliable because they cannot just keep changing their story. And this was emphasized in State versus Matonzi. In State versus Matonzi, where the court held that the effects of such statements depend on the circumstances of each case. Sometimes the inconsistency may be minor, other times it may strike at the heart of the testimony. Factors that affecting the impact on credibility. When deciding how much weight to give to previous inconsistent statement, the court considers the following: the nature of the inconsistency. It's about a small detail, or is it about the central issue? If it's about a small detail, maybe a witness says, when I arrived, at the shop, it was about to be closed. And then when he gets to court, he says, when I arrived at the store, it wasn't closed. It was not about to be closed as yet. So you see, the inconsistency is not really that major. However, if the witness comes to court and says, when I came to the shop was about to close, that this is the first initial statement. The shop was about to close, and then when I entered, I saw the manager stabbing the deceased multiple times. Then I ran out of the door. And then when it comes to the store, to the court, he says, when I arrived at the store, it was not about to close. What I observed, or rather, I couldn't really see clearly what was happening behind the glass door. So I can't really say that I did see the manager stabbed the deceased. So that's really a central issue now. So it's important that the court does establish the nature of the inconsistency and the severity of the consistency. Timing. Was the earlier statement made soon after the events, or was it made years later? Circumstances must also be considered. Was the earlier statement made out of under oath, in writing, or in a casual conversation? Explanation. Did the witness give reasonable explanation of the change? For an example, if the witness first said the robber wore a blue jacket and later it was black, it was a black jacket, that inconsistency is less serious. It might just be a memory failure. But if a witness first said that the accused was the one who robbed me, then later, no, it wasn't the accused, I don't know who it was. That strikes at the heart of the credibility. I hope you guys can follow. So now putting everything together, um, in practice, lawyers must be strategic when dealing with previous inconsistent statement. If one can show that the witness cannot be trusted, you weaken the opponent's case. But if the court are cautioned, they'll simply take the earlier statement as the gospel truth. They weigh both versions and examine the surrounding circumstances, then decide whether the witness can be relied upon. In closing, I just want to say that previous inconsistent statements is when a witness says something in court that contradicts the earlier statement. The procedure is set out in the English Criminal Procedure Act of 1865, and such statements do not prove that the facts, but they affect the witness credibility. This case of Steadfast versus Matonze reminds us that the impact depends on the nature of seriousness of the inconsistency. In our next lesson, we will then connect this with the hostile witnesses, because in a hostile witness is declared hostile precisely because they make previous inconsistent statement. I hope you can link the two, that usually in situations like this, you can declare your witness a hostile witness, linking it with the previous chapter that you just dealt with. So that puts us at the end of today's class. If you do have any questions, feel free to pop by my office and then ask the necessary questions, and then I'll be more than willing to assist in this regard. Thank you.